This video is not legal advice. It is for educational purposes only. It does not create an attorney-client relationship. Always consult a qualified attorney for advice specific to your situation.
In the 2010s, the California courts undertook multi-year efforts to keep pace with an increasingly paperless world. They modernized their information technology systems, while the state legislature repeatedly amended statutes governing electronic filing, and the Judicial Council substantially revised the corresponding rules of court. Those legislative and judicial council efforts sought to consolidate mandatory electronic filing rules, to establish consistent effective dates of filing across case types, to authorize electronic signatures, to clarify proof of electronic service, and to safeguard the rights of self-represented litigants. The result is the present form of Code of Civil Procedure Section 1010.6, together with California Rules of Court Rules 2.250 through 2.261 and Rule 3.751, as well as numerous local court rules. Section 1010.6 governs both the electronic service and the electronic filing of documents. It provides that a document filed electronically with the court has the same legal effect as a traditional paper filing. In conjunction with the associated rules of court, the statute authorizes superior courts to adopt local rules governing electronic filing in civil actions, subject to statutory limitations and the practical constraints of generally available word processing and portable document format (PDF) technology. Illustrative local rules include Alameda County Rule 3.27, Los Angeles County Local Rule 3.4, Sacramento County Rules 1.20 through 1.23, San Diego County Rules 2.1.4 and 2.1.4.1, San Francisco County Rule 2.11, and Ventura County Rule 4.05. Under these authorities, a court may itself electronically file any notice, minute order, or other document it has prepared, provided it maintains official court records in electronic format. Courts may also require litigants represented by counsel in civil actions to file documents electronically and to pay the associated costs. At present, electronic filing is generally mandatory for all attorney-represented parties in civil actions, and, pursuant to local rule, many superior courts also require attorney-represented parties to electronically file documents in family and probate proceedings. Common document exemptions include trial exhibits, documents submitted conditionally under seal, bonds or undertakings, ex parte applications, peremptory challenges, and other documents expressly identified by local rule. By contrast, self-represented litigants are not required to file electronically and must be afforded procedures for conventional paper filing. Any litigant who demonstrates that electronic filing would cause undue hardship or significant prejudice also may be excused from the requirement or may obtain appropriate fee relief. On a day the court is open for business, a document is deemed electronically filed if received between 12 a.m. and 11:59 p.m. that court day. A document received electronically on a non-court day is deemed filed on the next court day. The court must provide confirmation of receipt and of filing, or it must promptly notify the filer of the reasons for rejection. If the court's electronic filing system was malfunctioning or inoperative, a document may be deemed filed on the day a demonstrable attempt to file it was made. Electronically filed documents must generally satisfy the formatting requirements of the California Rules of Court. The required formatting must remain intact when the documents are printed. They must also be text-searchable without corruption of the underlying images. Although not mandated by statewide rule, electronic hyperlinks, which take the reader to other locations in the same document, are encouraged by many local rules. Exhibits must satisfy the tab requirements of Rule 3.1110F through electronic bookmarks and exhibit slip sheets that identify and separate the exhibits. Bookmarks are navigational tools that appear in the pane of a PDF reader. When selected, they take the reader directly to a designated page or location. Where full conformity with paper-oriented formatting rules is not feasible, the narrower statewide and local rules that govern electronic filing control. Electronically filed documents are not required to have digital signatures. A document that is not required to be signed under penalty of perjury is deemed signed by the person who filed it. When a document must be signed under penalty of perjury, it is deemed signed if either 1. A printed form bearing a physical signature was executed before or on the same day as the electronic filing and the original is retained for inspection, or 2. The document is signed by a qualifying digital signature that includes the declaration under penalty of perjury under the laws of the state of California that the contents are true and correct. When multiple signatures are required, all signatures must appear on the original hard copy document, which must remain available for inspection and copying. The electronic filing constitutes an attestation that the filed document contains all required signatures and that the original is in the filer's possession. A document requiring the signature of a judicial officer may be signed in any manner permitted by law. As for the logistics of electronic filing, both Section 1010.6 and Rule 2.252b contemplate either direct electronic filing with the court or indirect filing through a court-approved electronic filing service provider, EFSP. In practice, nearly every superior court receives electronic filings exclusively through approved EFSPs. These providers serve as intermediaries between the filer and the court's electronic filing manager, EFM, which is ordinarily part of a Tyler Odyssey or eFile CA or a Journal Technologies, eCourt, case management system. Each EFSP maintains its own tutorial, and it charges transaction fees in addition to the court's filing fees. Once an approved EFSP is selected, the process of electronic filing typically consists of the following 8 steps. Step 1. Consult and verify the court's current electronic filing rules on its official website, commonly under Self-Help, Electronic Filing, Getting Started, or similar headings. Step 2. Confirm that the documents are not exempt from electronic filing. Prepare format-compliant documents, including proofs of service and any required redactions of confidential information. Identify any lead document, and prepare any printed courtesy copies the court or department may request. Step 3. Create an account with the chosen EFSP if one does not already exist, selecting the appropriate court and supplying party names in the order they appear in the pleadings, payment information, contact details, and California state bar numbers for attorneys. Step 4. Log into the EFSP portal and select the document type from the provider's list, or a generic type with a concise name extension if the precise title is unavailable. The selection determines fees and court workflow. Step 5. Upload the documents in text-searchable PDF. Some courts or practitioners prefer a portable document format, archival, PDF-A version, since it ensures that the electronically filed document can be reliably opened, viewed, and reproduced with the same visual appearance generated by the litigant's word processor. The PDF also excludes those PDF features that make archiving electronic documents problematic. The PDF can be created directly with modern scanners or indirectly with a conversion tool such as an Adobe Acrobat application. Best practice additionally includes early filing, test submissions when possible, and compression techniques for files larger than the strict size limits set by courts and EFSPs, commonly 25 to 60 megabytes. Step 6. The EFSP transmits the documents to the court's EFM, along with the court filing fees paid by credit cards or through the EFSP by means of electronic checks. The EFSP should issue an immediate confirmation of transmission. All transaction numbers and confirmations should be preserved. Transmissions completed before midnight on a court day are treated as filed that day. Step 7. Court clerks review the filings and accept or reject them. Processing times vary by court and filing type, but they can take up to 2 business days or longer for proposed orders. Common grounds for rejection include oversized files, formatting defects, incorrect document names or types, missing courtesy copies when required, and missing reservation numbers for noticed motions. With respect to missing reservation numbers, bear in mind that motion hearing dates must ordinarily be reserved through the court's online reservation system. Step 8. Filing confirmations and notices appear on the EFSP portal. Hence, The portal should be monitored. An accepted filing yields a conformed, stamped copy that constitutes the official record. A rejected filing should be corrected and promptly resubmitted. If a deadline is implicated, emergency court relief may be necessary. Finally, mandatory electronic filing is accompanied by mandatory electronic service. Thus, a represented civil litigant required to file electronically is also required to serve and accept service of documents electronically, unless personal service is statutorily required, unless the action involves an unrepresented litigant who has not consented to electronic service, or unless the court orders otherwise. Electronic service is complete at the time prescribed by Section 1010.6. Any extension of time for a responding party is governed by that statute and other applicable procedural provisions. Mandatory electronic service is governed by Code of Civil Procedure Sections 1010.6, Subdivision B, and 1013, including Section 1013B, governing proof, together with California Rules of Court Rule 2.251.
Final reminder. The contents of this video are for educational and informational purposes only. They do not constitute legal advice and are not a substitute for personalized guidance from a licensed attorney, familiar with your specific facts and circumstances. No attorney-client relationship is formed by watching, liking, commenting, subscribing, or communicating through this channel. Laws change over time and vary by jurisdiction. Do not act or refrain from acting based on anything in this video. Seek advice from a qualified professional in your jurisdiction. The creator disclaims any liability for loss or damage claimed to result from reliance on this material.